Welcome to this seminar series, the last in our series of protest law webinars. This one we are looking at protest injunctions and contempt of court. Just to go through some of the housekeeping before we start, we're going to have three talks from three experts in this area of injunctions and protest law. We've got Stephanie Harrison, QC, Stephen Simblet, Queen's Counsel, and Tim Baldwin. We're aiming for about 50 minutes of speaking time shared between the speakers, and then we'll have some questions afterwards. For those of you who've attended these seminars before, you'll be familiar, but for any new faces, you have all been placed on mute. We would like questions, however, so please put your questions in the Zoom chat function. I hope you all know how that works. We will have the slides from this presentation will be circulated to those of you who have registered. Please also remember that this webinar is being recorded, and what that means is the audio and the video of the presenters and anyone who does speak, if they're unmuted, will be recorded, and the webinar may be shared on our marketing channels, including our website and social media. No other audio, video, or personal data will be recorded or shared. For any other technical issues, please look at the instructions in the chat. So, just to introduce the talks today, the title of the seminar is Protest Injunctions and Contempt of Court. And as many of you will already know, large corporations and local governments are increasingly turning towards injunctions to restrict the right to demonstrate. This webinar will look at challenging injunctions to restrain protest. We'll look at the recent litigation, including the INEOS, UK oil and gas, and Cuadrilla and Canada Goose cases. We have, as I say, three real experts in the field. The running order, so just to sketch out the direction of travel, will be Stephanie Harrison, Queen's Counsel, going first, followed by Stephen Simblet, QC, and then Tim Baldwin. Stephanie Harrison is a silk whose practice spans the breadth of public law and civil liberties. She's involved in groundbreaking work in immigration detention and national security issues. In the area of protest law, she has a particular specialism challenging injunctions seeking to restrict the right to protest, and she, along with Stephen Simblet, was involved in the majority of the early cases concerning injunctions under the Protection from Harassment Act. And more recently, she's acted for anti-fracking protesters, culminating in the Court of Appeal decision in the INEOS case, as well as the ongoing litigation in UK oil and gas and persons unknown. And Stephanie will talk about the substantive basis of bringing injunction claims. So Stephanie, over to you. I'm going to just share the slides for Stephanie's presentation.
Thanks very much, Owen. Yeah, so what I was going to do was to sketch out the torts that are generally used in injunction proceedings, some of which will obviously be very familiar: trespass, private nuisance, public nuisance being a particularly important one because that's rights over the public highway, and then consider some of the more elaborate statutory torts that have increasingly been used by companies and others under the Prevention from Harassment Act 1997, the Trade Union and Labour Relations Consolidation Act, which was focusing on trade union activities, but has been used increasingly outside of that particular sphere. And then in particular, looking at the recent use or attempted use of economic torts based on conspiracy to seek to bring wide-ranging injunction proceedings. So obviously it's a big topic. I can only give you an outline of some of the key issues, and I'll seek to do that by going through each of the torts that I've identified in the outset. The first one being trespass. So Owen, if you could just bring up the trespass slide.
The next slide.
Yep. Yeah, so obviously it's very usual and not that controversial for companies and others to seek to prevent protesters going onto their land without permission. And if that's the only basis of the injunction, it's going to be pretty difficult to challenge it. However, what is important is that cases such as Hall and Samidi have established that even in trespass cases where the trespass is related to the exercise of freedom of speech and assembly, it's not a strict liability tort. It does require there to be a balancing exercise where the rights of free speech and assembly are taken into account, along with other factors, in particular factors such as whether or not the protest is in breach of the law, whether or not the location is particularly important. In Hall, it was in Parliament Square Gardens, and that was obviously a historical site for protest and given weight. The duration of the protest, the degree to which there is an occupation of the land rather than trespass. Again, in Hall, it was occupation of the land because the duration of the protest went on for so long in 2011. And the court will be particularly keen to weigh up the impact of the protest on the rights of others, whether that's the property rights of owners or the members of the general members of the public in a context such as a piece of land like Parliament Square Gardens. It's right to say that distinctions are drawn where the land is public land as opposed to private land, and increasingly companies seek to press home a significant distinction between public and private land, relying on ECHR cases such as Appleby in the UK to say that the balance must be struck differently where it's private land. There's ECHR cases going both ways on that, and it's a contested area that you need to be familiar with. But the bottom line about trespass is that it's not a slam dunk for companies. They still have to demonstrate that any prohibition on the rights to free speech and assembly in that area is justified and proportionate. So then moving on to the other tort, again, which historically has been most commonly used and which is directly referable to rights over land, which is private nuisance, typically to prevent gatherings outside of particular sites, and to protect the right of entry and access to sites. Again, private nuisance does need there to be established two critical ingredients. One, it must be substantial, any interference with the right of access to property, and it must also be unreasonable. And that's based on, as you'll see in the next slide, Owen, thank you, the old cases that establish the ingredients of this tort. The fact that it's subject to a reasonableness requirement does mean that the rights to free speech and assembly will be factored into any tort just claim based on private nuisance, and allow you to argue that even if it does cause some substantial interference in the rights of access, your presence outside of a particular site is important, critically important to the effectiveness of your exercise of your rights, and therefore a balancing exercise again must be undertaken. One area that's really important is where your private right of access and entry butts directly onto the highway. And an important case in that context is the Hissock Syndicates case, which essentially said that even where you have a private law right, if it can only be exercised by people using the public highway, then it's going to be the higher threshold for interference with the right of access over the public highway that will prevail. And if we go on to the next slide, we can have a look at the ingredients of the tort of public nuisance. Essentially, what's been established for long standing is that public nuisance reflects the criminal offence under section 137 of the Highways Act. And so any public nuisance, any claim in public nuisance must establish that there's an obstruction, which is obviously a higher threshold than a substantial interference. It has defences within it, lawful excuse and reasonableness, so that the exercise of free speech and assembly will be factored into whether or not the obstruction, even if it's occurred and can be established as a matter of fact, is nevertheless lawful and or reasonable. The recent case last year, DPP and Ziegler, the divisional court has put to rest a great deal of debate that was being played out, especially by companies seeking to interpret the leading cases, DPP and Jones, in a restrictive way. That attempt by companies has been put to bed by Ziegler, and it's now well clear that that even where there is an obstruction caused by protest or demonstrations, gatherings, it would need to be established that it was not disproportionate to prevent it or impose penalties. So that's an important case, and certainly it informed that analysis informed the INEOS upstream case where the Court of Appeal struck out an injunction brought against persons unknown in respect of the tort of public nuisance as being impermissibly wide and uncertain and disproportionate, because it did not properly reflect the terms of that injunction in public nuisance, did not properly reflect the requirements of the freedom of speech and assembly. And that's an important development from the Court of Appeal last year. Ultimately, it's going to be a fact-sensitive question, and that's why the use of injunctions as a means of regulating effectively in advance where the balance is to be drawn in the context of public nuisance have increasingly been disapproved of by the courts. And if we just go on to the next slide, we can see the Canada Goose case where the Court of Appeal have accepted that and made important statements about the inappropriateness of civil injunctions to seek to regulate, in particular, protests over the public highway. And those quotes are particularly important to bear in mind because they actually go to the heart of whether injunctions should be brought at all, rather than just simply working out whether they should be imposed in a particular case. You'll see the final quote from there that invoking civil jurisdiction as a means of permanently controlling ongoing public demonstrations and the use of private litigation to prevent what the claimants see as public disorder is not appropriate. Private law remedies are not well suited to the task. One particular form of protest over the highway that has been the subject of a lot of litigation initiated in the fracking context has been slow walking, and the INEOS case ruled that attempts to prohibit slow walking forms of protest was unacceptable because it was too wide and insufficiently defined. So public nuisance is an important area where case law is now moving towards limiting the extent to which injunctions can be used to prohibit it. Going on then to the more elaborate statutory torts that have been used and to harassment, as Owen said, there was a very concerted effort by a number of different private companies engaged in particular in animal rights, in animal research and or in armaments provision from about 2005 onwards, were increasingly using the Harassment Act as a means of regulating protest. You'll see in section 1 what is prohibited. So course of conduct of two or more, harassment of two or more persons, and including what you see at C, intending to persuade any person not to do something that is entitled or required to do, or to do something that he is not under any obligation to do. You can see how that can have a very significant impact in the context of free speech and protests, which is obviously focused on trying to persuade people to do something different and to change their conduct. Clearly, the environmental protests is a lot about that. And if we just go on then to look at the next elements of the Harassment Act. So section 1(3) A to C provides the defences. C in particular has the defense of the conduct being reasonable, and that's the context in which, again, Article 10 and 11 rights have been brought into play. What is important about the Harassment Act and why companies resorted to it is because you'll see that, one, it creates a criminal offence, as well as providing for the remedy of injunctions, but critically 3C provided for a breach of an injunction to itself constitute an offence and therefore arrestable. So it engaged the police's powers to control protests rather than having to use coming back to court for contempt. And so for that reason, it was heavily relied upon. It has to be said that over time, the courts have moved away from endorsing the Harassment Act as an appropriate mechanism for regulating protests. And I've given you two cases there where the court said they wouldn't use that it was inappropriate to use the tort of harassment. The Heathrow case, because it was too wide and disproportionate in its effects. And then even in the INEOS case at first instance, although the judge granted very wide-ranging injunctions, which were subsequently overturned by the Court of Appeal, even Mr. Justice Morgan was not prepared to grant any injunction in harassment because of its intrusive impact on protest rights. So if we then move on to the next statutory tort, and this is Section 241 of the Trade Union and Labour Relations Act 1992. And as I said, it put into statutory force common law restrictions on the right to picket and secondary picketing. And it has been used, again, in the context of the anti-fracking demonstrations as a means of regulating and protest. Not to great effect, it has to be said, but it is important to be aware of its use because we'll go on to see how it's used as part of the conspiracy tort. The ingredients of the statutory tort include intimidation or annoyance by violence or otherwise. And an important case is the DPP and Fiddler case, which makes distinctions between activity which is based on dissuasion rather than one of compulsion. And the facts of that case are pretty stark because it was people protesting outside of abortion clinics in a pretty aggressive way with distressing images, etc., for the women who are having to go into that building. But the court drew the distinction and said even in that context, it was about dissuasion rather than compulsion. It's important to recognise that any conduct has to be itself a criminal offence or a tort, and it too is also subject to a reasonable justification defence, which therefore means, again, you bring into play the principles of both non-arbitrary interference with protest rights and interference that isn't disproportionate. So again, in recent proceedings, this time the UCOG case, the judge made no order at first instance under this provision because, one, it was too uncertain. They were seeking to prevent people being present outside of the sites and on the basis that what they were doing was watching and besetting. The answer of the protesters were, we are simply monitoring the activities on these sites to see if they remain within their planning permission, the activity being unconventional forms of extraction of oil and gas, and the judge refused to impose that part of the injunction based on the watching and besetting, because it was clearly going to prevent otherwise lawful activity pursuant to protest rights. So finally, then, the new development sparked by the INEOS line of cases was for companies to seek to use economic torts. So those are torts that are based essentially on conspiracies to injure and to cause economic loss. The key ingredients of them are that you must combine together with others with the intention of causing economic loss or damage, and do so by means which are either criminal or tortious. And it was in that context, as I said, that reference was used to the trades union legislation, because that creates conduct which is a statutory tort, and so they put the two together, as well as the other substantive torts as well. So the key challenge in terms of the impact on protest rights is obviously combining together is what people do in order to take part in peaceful protest. And so its chilling effect on ability to participate was significant. And for that reason, the court in INEOS upstream and the Court of Appeal concluded that as far as a Cuadrilla injunction was concerned, it was inappropriate and wrong, unlawful to use this tort as a means of regulating protest. The benefit of doing so for the companies, and the reason why they resorted to the use of this tort, was because it allowed them not just to seek to regulate conduct at their own sites, but actually to control protests within their supply chain. So it went wider than just the immediate area of their sites, and were therefore able to capture large numbers of other companies that had been the subject of some protest activity, asking them not to participate in supporting the fracking at the Cuadrilla and other sites. So it was potentially of wide-ranging impact on the effectiveness of those protests. But the court, for the reasons that I've said, one, that it's so broad; two, that it's uncertain in its terms, because you have to establish, combining together, you also have to establish an intention to cause damage, and you have to establish the damage itself. So for all those reasons, on a Cuadrilla basis, the court said it was unacceptable to bring proceedings under this tort. In the subsequent Cuadrilla case in the Court of Appeal, the court has said that it could be possible in a case where you've had past conduct and you've got actual individuals rather than persons unknown, permissible to establish this tort. It's not in itself unacceptable if you can make out the evidential case. And as I think we'll go on and see from Stephen's next focus on persons unknown, part of the justification that the companies have had for pursuing these cases is that they're actually unable to establish facts, and they seek to get around that by using persons unknown injunctions. So I think bringing that together, you can see that the companies have a wide-ranging panoply of torts that they can use. Ultimately, it's the torts relating to land, whether that's trespass or private nuisance, that have purchase and are difficult to defend against. Public nuisance is an area where the courts are actively engaged in seeking to limit the extent to which companies can control protest on the public highway, and they have not been amenable, certainly in the context of persons unknown injunctions, to using other wide-ranging torts under the Harassment Act and/or conspiracy to injure. So I hope that gives you a bit of a snapshot summary of the basis upon which these injunctions are being brought, and some ideas about how to defend against them.
Thank you very much, Stephanie, for that overview of the substantive torts involved in injunctions. Our next speaker is Stephen Simblet, Queen's Counsel. His practice focuses on 4 discrete areas: civil actions against the police, inquests, mental health, and judicial review. In relation to protest law, he's again an expert in challenging injunctions brought by private companies to restrict protest. He appeared, as been mentioned, along with Stephanie, in many of the early protection from harassment cases, and also in the INEOS and UK oil and gas litigation, where he acted for Friends of the Earth. He took silk in 2020, and he continues to develop his work in protest law and injunctions. and his talk will concentrate on the procedural issues arising in injunction cases.
Thanks, Owen. Right, let's get going. Let's start the slideshow. Are we sharing? Can you see that? Is that working? There we are. Is that better? There we go. That's working, isn't it? I hope so. Good, right? Yes, because I can't see myself. Right. So that's the title. That's who I am. Let's start with this. So, moving on from what Stephanie has been saying, basically claimants in these cases are trying to get the courts to help them in their private interests to remove people who you might think have legitimate rights to be there to protest. And so there's a whole range of tactics used, one of which, as Stephanie has taken us through already, which is to essentially seek to shoehorn their situation into various torts and proceed either in what you might call novel causes of action, or to essentially appropriate torts designed for something else and say that it's being used for this purpose. And they also, and this is what we're going to be looking at more in this talk, try not to have any opposition to any of this. They try not to name any defendants, try not to put people before the courts, and often try and proceed effectively in secret. So let's move to our next slide. So no defendants and persons unknown injunctions. So what we noticed, say, in the INEOS case was that the various claimants had brought their claims by simply setting out their allegations in evidence, and by evidence we don't mean the odd witness statement here or there. We mean 30 or so lever arch files, essentially just put before the court and saying to a judge, "We'll get on with it. We're entitled to injunctions in these various causes of action." And it's we got involved later, Stephanie and I. But essentially, it was extremely, on the face of it, draconian and unfair, because they were seeking orders that affected potentially everyone, and by everyone I mean potentially everyone in the jurisdiction, so everyone in Britain, proceeding on evidence alone without trying to set out what you'll have picked up from Stephanie's talk already, or often quite complicated and nuanced legal concepts that have to be put in proper pleadings and so on, and further, without serving anybody, and most serious perhaps, obtaining permission from the court to keep initial hearings secret. So the first that anybody knew of this was when the injunction orders were granted by the court, and the claimants started going around various bits of patches of land, some of which were alongside footpaths and so on, putting notices up, basically saying "keep out." I mean, it's sort of like in Viz, get off my land. That was what was doing. So all these people that lived up in Yorkshire and used these sort of fields to walk their dogs and so on, suddenly go out with the dog and find all these injunction signs up there. Now, the trouble, of course, with all of this is that although they're relying on these commercial tools to deter protest, the right to protest engages everyone's rights under the European Convention on Human Rights, including Article 10 and Article 11. There is, as we'll see, reference to there being common law rights to protest, in the rather limited sense discussed in INEOS in the Court of Appeal. And importantly, for the sort of things that Stephanie's been saying and also what we're saying here, injunctions are discretionary remedies. So the court doesn't, even if you can make out some sort of claim in tort, that doesn't necessarily follow that you should get an injunction. And that's particularly important in these sorts of cases, because under Section 12 of the Human Rights Act, the test for giving an interim injunction is not simply the usual balance of convenience test, and American Cyanamid and Ethicon and the cases that people may be familiar with for injunctions generally, but actually because it affects freedom of speech, it's an elevated test. So essentially, on the face of it, the claimant ought to be able to satisfy the court that they're more likely than not to get the order they seek at trial. So for people like us trying to resist this sort of thing, that's an important thing to be able to say, because actually all of the defences and so on to the various claims that Stephanie has been describing to us, and all of the sort of discretionary points about the various other people's rights of protest and so on, all of that can be put into play, as can things like the conduct of the company seeking the injunction. So quite often, if you get to an inter-parties hearing, we'll come on to that in a minute, one of the things you'll be wanting to say is whether in fact the claimants have genuinely put all the material before the court, and that was a big issue for us in INEOS. Now, there's a sort of tactical issue here, because on the one hand, if nobody turns up, the order will stay in place, and it ought to be on the face of it, as one of the points that we would always be making is that it is wrong for a court to make an injunction and further to maintain an injunction when there are no defendants before the court. And it was striking that in INEOS, the court was prepared to grant interim remedies on the... Can people see these slides, or have we got the Zoom picture overlaying them? We haven't got all the pictures of... on my screen, I've got pictures of all of us lot, but that's all right, is it? Right. In the INEOS case, not only had the injunction been made effectively in secret, but it included things to which there were good defences. And Stephanie's mentioned that at first instance in the INEOS case, we were able to knock out the claim in harassment. So turning up to make some of these points can be important. Although on the other hand, if you don't turn up, that might worry the court more, because of course the importance of judges accepting that there will always be two sides to any case. So in the Canada Goose case, which Stephanie has mentioned, Mr. Justice Nicklin, who was dealing with this at first instance, was dealing with a case in which there were no people before the court at all. So not just unrepresented people, but nobody. And that became to the court a real worry. And it was the problems with it for any judge being asked to make a discretionary order were set out in his judgment at various points. And I've highlighted this that he said at 149 to 151, where he made it clear that this is an emergency jurisdiction, which is provisional and strictly conditional, where you are proceeding against what they call persons unknown. And he set out some quite tight preconditions on when this would be appropriate. Now, Stephanie and I like to think that he'd read our skeleton argument from the INEOS case at first instance, because many of the things we were saying there seem to find their way into his judgment, and it's almost as if he'd followed the scheme of it. But it is interesting that in Canada Goose, not only was there no lawyer opposing what the claimants were saying, there was literally no one. And in some senses, that worried the court more than if people had turned up. On the other hand, there are all these points to be made. And Stephanie has already outlined the complex nature of the various torts that people are relying on here. And it's important to emphasize, fact-specific. So in Boyd and INEOS, but at that stage, the most restrictive and worrying injunction was to prevent conspiracy to cause economic damage by unlawful means. And it was possible to argue, and in fact successfully argue, that the claimants had because they hadn't proceeded with proper pleadings and then properly identified people, they also couldn't identify sufficient damage to satisfy the test that the court requires for an injunction to be made out. So essentially, they didn't have a sufficiently strong case in an essential element of the tort, so therefore it wasn't right to grant an injunction. Also, I've mentioned here that the Mr. Justice Nicklin's decision as a final injunction. He was dealing with an interim injunction, but he made clear that a final injunction is not available against persons unknown, and that decision was upheld on appeal in the Canada Goose case. Next point also is to consider actually whether, in fact, in any of these cases, the court can, that the claimants can satisfy the court of the requirements of Section 12 of the Human Rights Act, as I've mentioned already. Now, some other points to raise, therefore, if you get involved in something like this. Bear in mind that the INEOS approach of just essentially delivering wheelbarrows of factual material to the court without any proper formulated case is, on the face of it, not what courts expect. It ought to be appropriate for a claimant to have to use Part 7, because it is likely, in any case where they're seeking very wide-ranging relief, that other people will have something to say about both the legal basis of their claim, but also the factual basis. And essentially, they're alleging that loads of things happen in a particular way that, for instance, might constitute the tort of causing damage by unlawful means. Then there may be two sides to whether the means are either being used at all, or whether they are or are not unlawful. So it's wrong, we would say, for somebody to proceed with a Part 8 claim. So, but very often, as they had in INEOS, that is what happens. Somebody serves a Part 8 claim, and one of the things, if you're involved in resisting this, should be to contest the appropriateness and point out that the allegations of fact and so on are disputed. And then I'll come on in a minute to what I say about CPR 3.4 and striking out as an abusive process. And of course, we're not asking for much in these sorts of things. These are all elementary. The court ought to want to know who's there and why. The CPR Part 1 sets out the duties of the parties to assist the court, which include the ability to reach settlements or to make compromises, things like that. And if the claimants essentially proceed against persons unknown, i.e. everyone in the world, it's very difficult for them and for the court to comply with this. There is a definition in CPR Part 2 of a defendant, a person against a claim is made. If it is a person unknown, what is the basis of the claim against that person? Is there actually a person, or is it, as we were saying in INEOS, and ultimately were proved right about, essentially a sort of a cipher, or a sort of might as well sue the bogeyman point, that essentially if they invent somebody to impute all this unlawful conduct to, does that in fact cause further problems as to whether in fact they can make out a case in law adhering to all the requirements of the substantive torts, as Stephanie has just explained to us. And of course, how can you have a remedy if there's no one to apply that remedy to? So I'll move on, the time is ticking. In trespass, you can have a defendant who does not currently exist, because it is possible to give notice of the injunction to somebody who comes onto the land. And that is all explored and considered in a case called Gamel, which was considered in Boyd and INEOS in the Court of Appeal. However, as I've sort of mentioned already, there is a difference between a real and an imaginary defendant. And in EDO and Campaign to Smash EDO, in which Stephanie and I were both involved, one of the points that we took was that the Campaign to Smash EDO did not have legal personality, and they needed, if they were going to maintain proceedings, to find somebody that they said could represent this unincorporated association. In fact, in INEOS, we dug out a case called HSBC and Mooson, which isn't on the slide, where the claimant had brought proceedings on behalf of herself, her various children without a litigation friend, and a dog. And the point we were able to make in INEOS is, well, at least in that case, the court knew the dog was, whereas in these cases, they seem to be proceeding with, essentially to invent defendants on which they hope to pin the proceedings. Now, again, if you're going to turn up, litigate, don't capitulate, should you be applying to strike out? CPR Part 3.4, very often all of these limbs may apply in one of these. There may well be no reasonable grounds for bringing the claim against a defendant if there is no proper case made out in the substantive torts for in the way that Stephanie's been explaining. It's likely in many of these cases that if there are no pleadings, that the statement of case could be said to be an abuse of process, or it's otherwise likely to obstruct the proceedings. And the same in relation to failures to comply with rules, practice, directions, or court orders. That can be particularly important when it comes to issues of service, because in all of these cases, if you haven't got anybody to serve, then you haven't got a case. We'll move on to the next slide. There we go. There is a, I think we've got an out of order here. Yes, thank you. This next slide deals with one of the ways in which, one of the arguments in which it is said that the person's unknown procedure is unfair, because essentially there is a procedure under CPR Part 19.6 to bring proceedings against defendants where people have the same interest, and that is set out in some detail. It requires them to have a common interest, a common grievance, and a remedy beneficial to all. Now, if you've got people who are intent on climbing onto lorries, wearing balaclavas and so on in order to, at all costs, to stop the lorry moving, that might be one thing. But if you're going to go down there with your placard lawfully to stand on the highway for a short period of time protesting against something, that's very different. And whether in those circumstances all protesters have the same interest is likely to be highly controversial. A couple of points therefore on CPR 9.6. These are all, I'm not going to talk about them now because time's ticking on, but essentially the 19.6 procedure is one that you should be requiring the claimants to utilize, but then finding fault with along these sorts of basis, because not all protesters have the same interest in the case. They might have an interest in opposing the activities of the claimant, but they may not have the same interest or the same or have the same defences available to them. And certainly people who, if you can identify people whose only intentions are to protest lawfully, they can say, we have a defence, we have no common interest, we shouldn't be affected by this. And then I'll skip over this slide. That's quite an important procedural point on 19.6. And then move us on to this, which is also, even if you go down the representative proceedings route, there is a difference between people being bound by any sort of injunction that's made and people being liable to contempt proceedings. And these cases are all cases that Stephanie did, important victories to make clear that courts can't just give a sort of prospective carte blanche to enforce some sort of injunction against somebody who wasn't there. And the most important illustration of that is the N-Power and Carroll case, where Stephanie persuaded Mr. Justice Tier not to permit prospective enforcement against people who hadn't been brought before the court as defendants. And I think that's it. So yeah, that's my 15 minutes, or I've just gone over it, haven't I? That's my 15 minutes or so up, and I will stop my screen sharing and hand back over to Owen.
Thank you very much, Stephen. Now, the last speaker we have, but certainly not least, is Tim Baldwin. Tim practices in civil liberties and human rights, as well as housing, community care, and court of protection. He has a wide-ranging practice and has acted for protesters in a number of fields, including the UCOG injunction case, and he also appeared in the Latin Village and Haringey compulsory purchase order litigation. Before coming to the bar, Tim worked at the Law Commission and the Public Law Project, and he brings this public law experience to cases concerning the right to protest. Tim is going to talk to us about contempt of court proceedings for breaching injunctions.
Thank you, Owen. You'll see the first slide there. This is looking at a situation that after an injunction has been made, and the consequences for people, or potential consequences for them, should they breach that injunction. So what we're going to look at is the process that we're concerned about is when an application is made to commit somebody to prison or impose a penalty or sanction on them for breach of a common law injunction. As I said, there are many types of contempt of court under the Contempt of Court Act, and each one can have its own particular form of procedure to enforce a court order through imposing a sanction. But what we're going to look at quite briefly in this part of the webinar is the procedure and how an application to commit starts, preparation in respect of defending any application, and issues around funding and availability of legal aid to defend an application to commit, and the cost implications for losing or defeating an application to commit somebody to prison for contempt. The maximum sentence for breach of an injunction under an application to commit is 2 years in prison, but there are a range of sentences and penalties that can be imposed, and generally the guidelines issued by the Sentencing Council to sentence in criminal cases for breach of a criminal behaviour order is often used as a guideline by the court when a breach is proven. So what is the starting point? So the starting point is that the respondent has to be subject to a court order, namely an injunction preventing them from doing an act or requiring them to do something. And the respondent must be aware of that order, and it's always for the applicant to enforce the order. The court will take no independent steps itself in an application to commit. And for there to be a breach of the order proven, because there's a penal sanction that applies, the breach has to be proven beyond a reasonable doubt. And that is what leads to the application to commit to prison. But imprisonment is not the only sanction. You can have fines, you can have conditional or absolute discharges, and you can have suspended sentences. You cannot have the involvement of probation because it is not a criminal conviction. It is not something that goes onto someone's criminal record, but it can lead to people being imprisoned, and the terms upon which people are imprisoned are those that are governed by the court. So the court might say that you will be sentenced to 6 months in prison, but you serve only 3 months. So it is the sentence terms are those that are governed by the court. So what's the procedure? When there's no power of arrest on an injunction, those powers generally only apply to statutory forms of injunction. Part 81 of the Civil Procedure Rules apply, and the practice direction there apply, and particularly Part 2, Part 3. The general rules and the scope of interpretation are set out in Rules 81.1 to 81.3. And the key provisions that we're going to look at is enforcement of judgment or order or undertaking to do or abstain from doing an act. And that's under Rule 81.4. And 81.4 sets out the procedure in respect of applications for committal in respect of injunctions. The object, as you'll see if you read 81.4, is to ensure compliance with the terms of the injunction. And this is concerned with procedure only, and it doesn't confer on the court the power to make an order for committal, but the rules do recite the elements of contempt liability. It's applicable both in the High Court and the County Court, and in order for the procedure to be engaged, it's necessary to establish the order was made, the respondent was aware of it and of its terms, and thus knew what they were required to do and when. The procedural step requiring permission to bring an application, there isn't one. They just have to, they have a right to bring it. but disproportionate committal applications can be viewed as an abuse of process, and the court is often astute to detect when contempt proceedings are not being pursued with legitimate aims. And it is in appropriate cases, it may be open for a respondent to strike out the application as an abusive process. So there are various other rules, those governing the requirement of service, the methods of service, and dispensation with personal service. And there's a requirement that there must be a penal notice on the injunction identifying what the potential consequences are for somebody who breaches that. And Rule 8110 sets out the process for making the application, and this is backed up by Practice Direction 81. And 8110 sets out the process. The application is generally brought under an application made pursuant to a notice under Part 23, must contain a penal notice, and grounds must be set out in full why committal is sought, and the amendments are only allowed by permission of the court, and the judge must confine themselves to allegation in the notice. Procedural defects may be waived, but only if there's no injustice to the respondent, and it may not be discontinued without the permission of the court. So once it's brought, the court really get a grip of the proceedings. And it's open to the court to strike out an application, and there must be a witness statement by way of affidavit or witness statement filed in supporting evidence. And there must be an adjourned hearing date, which can lead to an adjournment or a stay. The rules set out what happens in the hearing, and there's also a power to suspend the execution of a committal order, and 8130 deals with the issue of the warrant of committal. And various other rules deal with discharge of person in custody. So that in an outline is the process. It's very much of a rules-driven process once an application is made. So when you are confronted with an application to commit, the key things to start thinking about and considering is there a defense to the grounds claim? Is there a defect in process or procedure in the way that it's brought? And is the person who is served with the application to commit, are you really the respondent or subject to the terms of the injunction? And are there grounds to make an application to set aside the application and actually set aside the injunction? Because with some people, this may be the first time in which they're actually aware that they may be subject to an injunction, where particularly when you have somebody who is classified within the group of defendants as persons unknown. And you can vary the terms of the injunction as well as defending the breach. So there's a whole lot of things to think about. And if you are presented with an application setting out grounds of breach, think about preparing grounds of response. Do you want to test the applicant's evidence? So you look to generate witness statements and look for witnesses to that effect. If you're going down a very complicated set of proceedings, you might want to adjourn for a contested hearing with oral evidence and cross-examination, prepare very detailed case management directions, and seek lots of disclosure, including orders where you have possible sanctions for non-disclosure and good preparation of witness statements and trial preparation. So it can be a fully contested trial. And as you recollect in the Yaxley Lennon case, one of the concerns about those proceedings was whether there was a fair procedure in the way that the court approached a committal application. And appeals from committal and committal orders, you don't require permission to appeal under Rule 52.3. So particular cases of interest, in addition to those that Stephen and Stephanie have talked about, these relate primarily to contempt proceedings. So, and the protesters were found in contempt at first instance and sentenced to imprisonment. Various questions arose as to whether the injunction was sufficiently clear and certain to allow committal. So it has to be sufficiently clear and certain, and whether suspended orders for imprisonment were an appropriate sanction rather than direct imprisonment. And interesting, the standard of review is set out in paragraph 85 of the judgment, the standard review on appeal. And what the appellate court said, it will only interfere if the judge, one, made an error of principle, two, took into account immaterial factors or failed to take into account material factors, or reached a decision which was outside the range of decisions reasonably open to the judge. So it's almost like a judicial review type of review on appeal against sentence. And the question here was really whether the lower court was wrong in respect of the sanction that was imposed for contempt. And one of the key things that was considered was the judge was wrong in respect of the appellant's exercising the right to protest. It was protected both by common law and Articles 10 and 11, regard or misapplied the sentencing guidelines from the Sentencing Council. And from this, you get the idea that the right of protest is an important right to be considered. Any interference with that right has to be lawful, necessary, and proportionate, and not only in respect of the injunction, but also in respect of the sanctions imposed as a result of breach. And that clearly required a justification to interfere with those rights by way of imprisonment. And also the clarity of the injunction is essential. The terms have to be clear and sufficiently precise to enable persons potentially affected to know what they must not do. And on sentence, one of the things that was considered was the protesters' motivation. And the Court of Appeal identified there should be greater clemency or leniency to non-violent acts or no circumstances of actual damage. And that led to an imposition of a variation of a suspended sentence. So it is worth looking at this case in great detail if you have a protest case where someone is said to have breached an injunction, and how sentencing is supposed to be dealt with if that breach is proven. Just to advertise a case that is of interest that Owen was involved in, and this is Sheffield City Council versus Brooke. And it was not necessarily an injunction case, but a similar type of order where there was an application to commit following an intentional breach of an undertaking. And the court held that in principle, it was a defence to a prohibited act to act in defence of another, where a protester generally believes that another protester was in imminent danger of being assaulted by a security guard acting on behalf of the local authority. And it's been reasonable in all the circumstances to breach a condition of an undertaking to defend another. So there's a reasonableness issue arising in respect of a breach of a condition. So there's an argument, do you look at necessity defences? How closely do you look at defences that might mirror defences that are available at criminal law. When Owen and I discussed this many years ago, we had a look in the book Arledge on Contempt at this issue in detail, and this was a novel matter. Nothing in Arledge on Contempt touched on this sort of defence or these types of defences. So one has to think creatively in defending these types of applications. So funding the defence. Legal aid is available under LASPO. The difference is that if you were eligible for legal aid to defend an injunction, that would be civil legal aid. But the problem now is that it's criminal legal aid. So it's looked upon as quasi-criminal proceedings. The advantage is that it's not subject to a means test as in civil legal aid. So anyone subject to the interest of justice test would have access to criminal legal aid. The difficulty is that many people are not aware of that. And there's a helpful direction given by the County Court at Central London, informing people once they're made subject to contempt proceedings. The County Court guidance is in paragraph 14, Schedule 3, Criminal Legal Aid Remuneration Amendment Regulations 2014. And in some cases, the higher courts, such as the High Court and the Court of Appeal, can grant legal aid in contempt proceedings, and the guidance of how to apply for legal aid is set out in the REF Committal to Appeal to 2018 EWHC case there. So legal aid is available to fund a defence. It's not means tested. It's paid at a lower rate, I think, than civil legal aid, but it is there because the proceedings are looked upon as quasi-criminal. What happens, win or lose, is cost protection available under Section 26 of LASPO? The short answer is no, as it's not civil legal aid, it's criminal legal aid. So if somebody loses a defence or is made subject to being proven to be in breach of an order, they would in principle be liable to pay the cost of the applicant. What sort of order to seek then if you are representing somebody who has been found guilty of contempt? You would want any costs that are applied for to be assessed, and also you would want somebody's means to pay those costs to be assessed. And ideally, you'd look for a no order as to costs in respect of a proven breach, particularly if that breach is minimal or if that breach unfortunately leads to somebody being committed to prison. Defending cost applications, you have to really think about addressing that and addressing the quantum claimed. Is it reasonable for that level of cost to be recovered? The counter argument is, well, what if a committal application is dismissed? Can you recover your costs from the applicant, and can it be at inter partes rates? You can recover the cost if legally aided, but not at inter partes rates, as it's not civil legal aid, and there's a strict adherence to the indemnity principle. That slightly broke Owen's heart when I told him about that in the Sheffield and Brook case, that he was limited to his criminal legal aid. So I'm going to stop at that point for people to ask any questions should they have them.
Thank you very much, Tim. Can I encourage people, please, if they have any questions for the speakers, to put them in the chat function. Whilst we're waiting to see if anyone is brave enough to ask a question, I might use my role as chair just to pose the first one. And one issue which I think I find interesting in relation to injunction cases is that it is a means by which protest is regulated essentially by private companies, and that is a contrast to the role of the police acting on the ground, using the criminal law to regulate protest, which is perhaps something people are more familiar with. And I just wondered if the speakers have any views or any comments on any constitutional issues that arise from that difference of approach.
And should I answer that first? I think that's been one of the underlying major issues of concern, which is companies have not been shy in explaining that part of their reason for resorting to civil injunctions was because they were unhappy with the decisions that were taken by the police on the ground in policing the protests. In the INEOS case, they said in terms, we are not happy with the way in which the police have decided that certain forms of protest, for example, slow walking, is lawful. And so they then resorted to using the civil law and their private life rights in the commercial courts, in the Chancery Division, where they got a better hearing. And there is a clear constitutional problem with a judge sitting in the High Court balancing commercial interests against public interests, and where the balance should be struck. And I think that's why the Canada Goose judgment of Nicklin upheld in the Court of Appeal is so important, because they do say civil proceedings are not the appropriate mechanism for determining what are essentially fact-sensitive questions, where the police have the appropriate powers provided by Parliament under public order legislation, etc., and are able to more appropriately make judgments about it. So I think that's been a big step forward in terms of constraining the use of civil proceedings. I hope it will be in the future.
Stephen and Tim, do you have anything you want to add to that?
No. Every time I've been working with Steph and we've been doing our skeleton argument, she polishes off this citation from Laporte and the Chief Constable of Gloucestershire, and we were all very pleased when Mr. Justice Nicklin nicked it and put it in his Canada Goose judgment.
I mean, I think there is an additional concern as well, and that is when companies are then when they do make applications to commit, often one of the and if someone is proven in breach of an injunction, often the cost orders that are made are huge, because the solicitors' firms that are used to bring these applications are often commercial city firms, and there is not a real astuteness to assessment or evaluation of the reasonableness of the cost orders that can be made in some of these in some of the breach cases.
Thanks, Tim. We've got a question in the Zoom chat from Christopher Ratcliffe. He's addressed it to Stephanie, but I think if anyone wants to speak, they should feel free. It says, as with an application, a moreover injunction, is there a similar duty of full and frank disclosure in applying for an injunction against persons unknown, and a need to set out what an individual defending would be anticipated to say?
That's an interesting question, and the answer is, as with any injunction being applied for in one-sided proceedings, the court expects the applicant to provide full and frank disclosure. We spent a lot of time in INEOS trying to impress upon Mr. Justice Morgan that what the claimants had done was well short of that, because actually, and he wasn't interested in it at all. But in fact, the law is very clear on it. There are a number of cases that we dug out about it. And in fact, and importantly in this area of law, if you are able to persuade the court that the claimants did not comply with their duty of full and frank disclosure, that is of itself an independent ground for setting aside the injunction, even in circumstances where the injunction would otherwise have been granted even if they had complied with their full and frank disclosure. Essentially, it's a quasi-disciplinary power that is supposed to affect the discretion that the court will use in deciding whether to maintain an injunction. So yes, what you're asking, Chris, about the Moreover injunction applies here, and it does actually have real traction in a couple of important additional senses. The first is, as Stephanie has taken us through, many of these torts are fact specific, and it ought to be required, or the claimants ought properly to be apprising the court of what the defences are. And secondly, as was in my talk, because we're dealing with things that affect freedom of expression, there is this Section 12 test under the Human Rights Act, which affects the court's approach to the injunction. If the claimants do not bring that to the court's attention, then that, in my view, would be a reason of itself to deprive them of an injunction that they might otherwise have had.
Probably what's illustrative of the failure in the INEOS case is in the box that says, does this case concern human rights? They tick no. But it took us quite a long time to establish that it did. Not only that they did, but they were being breached. But that was how lame or inappropriate the way in which they brought the case initially, and on a secret basis, because the order was made ex parte.
I mean, there are very strict rules about what an applicant has to do when they seek an ex parte injunction, be it a Moreover injunction, be it a freezing order injunction. All of those rules are very strict and they need to be complied with, because really, what is the justification for doing things ex parte rather than inter partes? And if you do it ex parte, you have a higher duty of to the court and disclosure.
Thank you. Well, if no one else is typing any questions away, that brings us to the end of our time. I just would like to thank our speakers for the interesting talks. I would like to thank very much Amy Hughes from the marketing team for arranging these seminars, and to thank all the participants for attending. This is the last of a series of webinars on protest law, and I hope that people who've attended them have found them useful. We've seen that there have been a range of creative legal arguments that have been put forward, but I think that's only a reflection of the vibrant and creative and determined actions of activists to bring forward issues into the public domain, to demonstrate on matters of importance, and to try and bring about change. Thank you all for attending. Bye.